It is a great privilege and genuine pleasure to have been asked to give this inaugural lecture named in honor of Sir Eli, and I'm very grateful to the Lauterpacht Center and to the Faculty of Law for their very kind invitation to deliver this lecture. I have just returned from a visit to Melbourne, where well over a generation after Sir Eli's 3 years of service as the Chief Legal Advisor in the Australian Department of Foreign Affairs, he is still spoken of with deep affection and admiration. I would hope that the choice of the topic for this particular lecture, which combines elements of both history and international law, suitably intersects with Sir Eli's intellectual interests and his corpus, and the focus on diplomatic correspondence between Great Britain and the United States coincides with this view of the practical importance of international law. I undertake the task, however, with some trepidation, because in the audience today are three of my former Cambridge tutors, Mark Weller, Robert McCorkadale, and Judge Christopher Greenwood, who helped me cut my teeth on international law and the use of force. So if anything goes awry, please blame them. It's also wonderful to see former members of the LLM class speaking here today, Emanuela Gillard and Robert Volterra, and in the audience, Therese O'Donnell, who has shared with me many of her gifted insights on how to handle historical material. It's lovely to be back in Cambridge. To begin the lecture today, the question, I think, probably on most of our minds is, why a return to the Caroline Correspondence? In this year alone, we have had two high-profile political speeches that have invoked by name and in some detail the incident of the Caroline, one delivered by the UK Attorney General, Jeremy Hunt, in London on January the 11th of this year, where he lauded the UK's role as a world leader in promoting, defending, and shaping international law, and the resulting correspondence as producing what he called the first known statement of the law of anticipatory self-defense. And the other by the Australian Attorney General, George Brandis, delivered in Queensland in April of this year, where he spoke of the Caroline as setting down the foundations of anticipatory self-defense doctrine. But he argued that technology and the nature of national security threats have been revolutionized and that these would have been utterly unrecognizable to the authors of the Caroline Correspondence. The broader public, too, have been introduced to the niceties of juridical doctrine. An article appearing in the New York Times in August of this year on the matter of another apocalyptic presidential tweet asked if the US attacks North Korea first, is that self-defense? And it went on to recall the renowned Caroline refrain, reminding its readership that this had been penned at the hand of an American Secretary of State, Daniel Webster, in April 1841. However, given the audience here today, as a matter of doctrine, it behoves us to consider the historical record, because what the Caroline Correspondence delivered and what it was actually about now seems to be a matter of high and indeed current contention. James Crawford, as Special Rapporteur of the ILC project on state responsibility, wrote in his commentaries to that project that the Caroline incident of 1837, though frequently referred to as an instance of self-defense, really involved a plea of necessity at a time when the law concerning the use of force had a quite different basis than it now has. And this explains why the Caroline incident was considered under the rubric of necessity in Article 25 of the ILC Articles on State Responsibility, and not under Article 21 relating to self-defense, a point he repeats in his general part of 2013 when he discusses Caroline. For his part, in his entry to the Max Planck Encyclopedia of Public International Law, Chris Greenwood considers that the impact of the correspondence on the law of self-defense and on individual responsibility, where he talks about an individual may not normally be held personally responsible for an act not of the state, for an act of state, but where state responsibility, and indeed the pivotal point of the plea of necessity, is not even mentioned. as pride of place is given to Chris's analysis to the law of self-defense. It seems to me these are strikingly different positions, one held by James, one held by Chris. And if it is not too late to ask the organizers of the dinner for the seating arrangements this evening to put James in close proximity to Chris to see how far judicial harmony will sing us into the good night. Contrast again Ian Brownlee, who in his magnum opus, appearing in 1963, said of the significance of the Caroline Correspondence, the statesmen of the period used self-preservation, self-defense, necessity, and necessity of self-defense as more or less interchangeable terms, and Caroline's diplomatic correspondence was not intended to restrict the right of self-preservation. So to start the analysis of my lecture, I think that these reflections provoke two preliminary and indeed two immediate responses. The first is to discuss the normative milieu in which the Caroline Correspondence took shape. There is no doubt about the existence and importance of self-preservation, a term we barely discussed today, within the discipline of international law in the 1830s. Henry Wheaton accorded an entire chapter to the topic in the first edition of his Elements of International Law of 1836. And in his treatise of 1905, Oppenheim traced self-preservation back to the earliest time of the existence of the law of nations and wrote of it variously as a motive and a right for any state to move against a violation against itself. But in the end concluded that self-preservation and the protection of the balance of power were admissible and excused interventions, as opposed to interventions undertaken by right. This is very important for us because what it suggests is that in the context of understanding self-preservation, self-defense, they were not without any normative context. And indeed, when one looks at Oppenheim's analysis, Oppenheim looks at the analysis of self-preservation in the context not of the prohibition of force, which did not exist at the time, but of the prohibition of intervention. And this is the essential contextual premises which informs the correspondence as it takes shape in the 1830s. The second reflection to make is that these two main interpretations that I've singled out, one of necessity as advanced by Crawford, and the doctrinal interchangeability as put forward by Brownlee, are interesting to us because they tend to emphasize a certain thematic constant that transcends the correspondence as a whole. They could be prone to suggest that at any given moment in time, the Caroline Correspondence stood for or represented one particular thematic or the other. And given the fact that the correspondence lasted from January 1838 to August 1842, 56 months in total by my count, I was eager to try and capture what, if any, evolutionary dynamic in the argumentative patterns began to emerge from the correspondence. What narrative emerges when these diplomatic missives are read one after the other, consecutively, as a whole? What insights reinforce or depart from the professional patois that we now cite to one another with great frequency and without much further thought, coming forward from Daniel Webster's formulation of April 1841? So to turn to the correspondence itself, and this is where I think the first great revelation emerges. The correspondence was actually a correspondence of two halves. 44 letters were written in total, 15 letters in the first set, January to June of 1838, and in the second set, we have December 1840 to 1842. The main interlocutors of the first set, if I can work the main interlocutors of the first set were John Forsyth, the Secretary of State for the United States, and Henry Fox, the British minister at Washington. This is the earliest incantation for the British representative in the United States. It subsequently became the minister plenipotentiary before the legation was actually replaced by an embassy in 1893 and the post changed to an ambassador. But in the period that we're looking at, we're actually looking at Henry Fox as the minister and John Forsyth. And in the second set, Daniel Webster, who had replaced Forsyth as Secretary of State, and Lord Ashburton, who had replaced Fox. In fact, Lord Ashburton, the British minister in Washington, was the recipient of a rather interesting tract written by Robert Fillimore in 1842, the very year that the correspondence ended, a decade before Fillimore published his commentaries. So what I want to do today is I want to analyze what happens in both of these sets of correspondence, and why were there two sets? So the significance of the first set. Theoretically, I set my compass on looking at the correspondence that happened after the Caroline occurred on December the 29th, 1837, as Michael Wavell said in the introductory comments. But in reality, there was some correspondence relating to the incident that in fact anticipated its occurrence. So in a letter of December the 23rd, 1837, from Sir Francis Head, the Lieutenant Governor of Upper Canada, to Henry Fox, he advised that the peace and security of this province are at this moment threatened, and that the territory is actually invaded by a large band of American citizens from Buffalo. So what had actually happened was American citizens who were very keen to spread the spirit of 1776 north of the border had begun to populate on Navy Island, which is on the Canadian side of the border from the map, and assist the Canadians in their insurrection against British rule. So one of the striking factors to emerge from that first set of correspondence is not that we're dealing with necessity or self-defense at all. It seems to me that we're actually dealing with self-determination before international lawyers begin to impose their formalist rubrics on the actual documentation. So this is very key to us to understand that actually what's happening on the ground may be very different to how doctrine is receiving it today. But quite critically, there are also complaints that are made by the representatives in Canada to the American authorities based in Buffalo that they are not doing enough to enforce United States neutrality laws. And this is in remarkable contrast to what happens in 1911 at the time of the Mexican Revolution, when the American government actually sent 20,000 soldiers as reinforcements to stop Americans going into Mexico. So there's no need to build a wall. We just need 20,000 troops to do the job instead. The second issue to arise from these diplomatic exchanges, the first set of diplomatic exchanges, is that they aren't just letters, they're actually vehicles that put forward the facts by way of affidavits and depositions coming forward from the individuals who were actually involved in the Caroline incident of 1837. And that's the critical night that British forces decided, based in Chippewa, to actually try and cauterize the Caroline, because it had been rented, it was a private vessel, to ferry men and munitions to Navy Island. And just to give you an example of how many individuals were on Navy Island, at its height it was estimated to be about 10,000 men, with about 29 cannon at their side. So the Caroline was very much pressed into service to assist this insurrection, to assist this rebellion. And the facts that emerge are that the Caroline was found docked at Fort Schlosser in the state of New York. It was cut from the ice that fateful evening, set aflame, and sent down the Niagara Falls, although there are some contentions that really put that into dispute. The third reason why I think that correspondence is interesting, the first set of correspondence, is that it actually maps out the initial justification that the British put forward for having destroyed the Caroline. According to the letter that was sent by Henry Fox on February the 6th of 1838, the piratical character of the steamboat Caroline and the necessity of self-defense and self-preservation are what inspired us to act. So here we see that Brownlee is actually quite correct in his transposition of what is happening, because what is happening in that very letter is that there is a combination of justifications: piratical, self-defense, self-preservation. But the fourth and final point why the first correspondence is quite interesting to us is because it ends in June of 1838 without any resolution. The British simply give that justification, and they think that is all they need to do. And under severe American persistence, they refused to respond to the letters asking for a more calibrated legal response. And one wonders why Britain doesn't really take any response to this. It could well be that Britain felt it did not need to answer to the sovereign equality of a former colony. Who knows? The key point, I think, to raise, though, is that the correspondence ends with the American Secretary of State, Forsyth, saying to the American ambassador in London, it's time that you take over the discussions with the London government. So we see a transfer, a jurisdictional transfer of this search for a legal justification for further accountability under the rules of international law as they existed. And then we come to the second set of correspondence. Now there's a long gap of a year and a half where we have no correspondence at all dealing with Caroline. And that I find very interesting because it's resurrected in December of 1840 on the apprehension in New York State of an individual called Alexander MacLeod. Alexander MacLeod had been caught bragging in a tavern one evening that he had been involved in the destruction and the arson of the Caroline, and he was actually apprehended, and Britain decided to respond to this apprehension by writing quite a passionate letter to the United States, not only complaining of this, but also demanding his immediate release. And the reason why they did that was they said that the destruction of the Caroline was a public act of persons obeying the constituted authorities of Her Majesty's province. This is very much Chris Greenwood's point in tow. The idea was that this was not a personal act, this was a public act of Great Britain at the time. And the Americans do not actually take kindly to this. They respond by saying that under the constitutional structure of the United States, the executive operates in a system of separation of powers, and that there was no way there could be any form of executive intervention. But that second set of correspondence is more important to us today because it is in that correspondence that Webster's formulation actually begins to feature. And this is the famous refrain that I mentioned earlier on. And I'll read out the key part of it for those who have not seen it before. It will be for that government, Her Majesty's government, to show a necessity of self-defense, instant, overwhelming, leaving no choice of means, and no moment for deliberation. It will be for it to show also that the local authorities of Canada, even supposing the necessity of the moment authorized them to enter the territories of the United States at all, did nothing unreasonable or excessive, since the act justified by the necessity of self-defense must be limited by that necessity and kept clearly within it. So I want to make 4 comments on this formulation. First of all, one thing that strikes the reader as one engages with a correspondence in an intimate way is that self-preservation is actually reduced in terms of how often it is mentioned in the correspondence. So as Webster takes control of the correspondence, we see a much more pronounced recourse to the issue of self-defense in terms of the language. And this, I think, is very important. And it's important because it's in that context that any notion of necessity is invoked. So actually, we see a progression from self-preservation and self-defense very much to self-defense, and it's in that context that, as I say, necessity is actually invoked. Secondly, I want to be clear, from the passage that I've read out, there are 2 Caroline principles that emerge, the principle of necessity and the principle of proportionality, rather than the 3 principles that Yoram Dinstein say exist. Yoram says that there's necessity, proportionality, and a 3rd criterion of immediacy. There's also evidence that Judge Schimmer, in his separate opinion in Oil Platforms, believes the same. But I think it's very clear to me that the immediacy of the response, the timing of one's response, is very much tagged onto the notion of necessity. It's part of demonstrating that there is actually a necessity. The 3rd point I want to raise is it's very clear that Webster intends separate functions for each of these principles, the principle of necessity and the principle of proportionality. Why do I say that? it's clear from the language, and it's clear from the remaining correspondence. It suggests that the necessity of self-defense must exist in order for force to be authorized. That's the key critical point, that once you demonstrate necessity, that is what authorizes you to trespass in another state's territory, to overcome the principle of non-intervention. And I think that that needs to be underlined, because it seems to me that necessity has been distorted in subsequent readings of the correspondence. So necessity is actually first up in terms of the reckoning presented in this correspondence. And secondly, proportionality comes into play to measure the quantum of violence in a self-defense operation when taken as a whole. The last point I want to mention is the interaction between these two principles of necessity and proportionality. Because it seems to me that this is a relationship that is both temporal and substantive in nature. It's temporal because the principle of necessity had to apply before the principle of proportionality. They apply at different times in the exercise of the right of self-defense. Necessity applies in order to activate the right of self-defense. Proportionality applies in order to provide a conclusive definition as to whether or not self-defense has been lawfully activated. And secondly, there is a substantive significance that exists between these two principles. They exist as part of the same package. There must be necessity before we can actually start thinking about proportionality. Proportionality is meaningless without any demonstration of necessity. So I think these critical points in hand suggest to us that by an intimate reading of the correspondence, we're able to actually form a very clear view of the practical framework that both of these authors, Secretary of State Webster and Lord Ashburton, had set out in turn. What about the subsequent reception of these principles in practice? Christine Gray says in her excellent text on the use of force that the Caroline episode has gained a mythical authority, by which I take to mean that it has an assured omnipresence in international law. We understand what the Caroline principles are, referred to as canons in the Nicaragua case, conditions in the nuclear weapons case. We all know what we're talking about when we talk about these canons or criteria. This is the mythicality of Caroline. And yet, a page or so later, Christine Gray goes on to say, these requirements are not expressed in the UN Charter, but are part of customary international law. There has been relatively little general academic discussion of these essential characteristics of self-defense, as opposed to their discussion of their application to particular incidents. I agree wholeheartedly with this observation. We are taught, and in turn we teach, a heady and happy synchronicity of the law on self-defense that combines dutiful references to the UN Charter against the enduring, if muffled, soundtrack of the Caroline Correspondence, which few have read. But need this be so? Faced with the claim of the United States in the Nicaragua case that the right of collective self-defense had been invoked in the event of an armed attack, I wonder if one route open to the court on that occasion would have been to have given short shrift to the relevance of the Caroline in circumstances that were entirely different to those we met in the situation of Caroline. There had been an armed attack here, even though in the 1830s there had been an invasion of Navy Island, but it wasn't characterized as that then. After all, this locus classicus of the law of self-defense, as Robert Jennings wrote on the occasion of the centennial of the correspondence, was a local classicus of anticipatory self-defense. And so one must wonder whether or not it was open to the courts to actually simply jettison Caroline in the Nicaragua case and apply the customary law dealing with situations of self-defense in an armed attack. However, the court was at pains to point out in paragraph 176 of its judgment that the Charter, having itself recognized the existence of this right of self-defense, does not go on to regulate directly all aspects of its content. And the example it gave was the operation of the principle of proportionality. The Charter, the court concluded, does not contain any specific rule whereby self-defense would warrant only measures which are proportional to the armed attack and necessary to respond to it, a rule, the court said, well established in customary international law. So here the court anchors the Article 51 conception of self-defense as reflected in custom, one that concentrates on the requirement of armed attack, to an even older international custom, the well-established custom of proportionality. Almost invariably, this conjures up the deep sensation that we are being transported back by the court to the root of it all, to the very terrain of Caroline. The court knows it is doing this, and it knows that we know it is doing this without the need to tell us that it is doing this. Hence the keen impression of mythicality, a sort of telepathic jurisprudence between the court and its readership. But having co-opted the principle of proportionality from Caroline into its reasoning, what role then for the principle of necessity? What of the authorizing function of this principle as ordained by the Caroline Correspondence in the event of, rather than in anticipation of, an armed attack? If an armed attack occurs, does that fact alone not authorize force against the attacking state? In paragraph 237, the court did speak of a necessity justifying the United States action against Nicaragua, but it went on to say, since the court has found that the condition sine qua non required for the exercise of the right of collective self-defense by the United States is not fulfilled in this case, the appraisal of the United States activities in relation to the criteria of necessity and proportionality takes on a different significance. As a result of this conclusion of the court, even if the United States activities in question had been carried on in strict compliance with the canons of necessity and proportionality, they would not have thereby become lawful. To my mind, this approach has the effect of structuring the regulation of the right of self-defense according to the following formula. One needs an armed attack, and then one needs also necessity and proportionality in order to demonstrate lawful self-defense. And it is a structure very much followed in the oil platforms case, where, after having interrogated whether the United States had been the victim of an armed attack at the hands of Iran, the International Court of Justice spoke of the nature of the target of force used avowedly in self-defense. Was the destruction of certain oil platforms satisfactory for the necessity principle? And that's how the court applies necessity. For me, this concentration on the target of force, on what the force is used for, on the ends to which it is actually put, is separate and subsequent to the actual fact of force, to the recourse of force in the first instance. I would suggest that there has been a subtle realignment of this function of necessity in the jurisprudence of the court, doubtless brought on by the interposition of an armed attack earlier in its reasoning. And I think that one can see this tension in some of the individual opinions of judges, such as Judge Rigaud and Judge Al-Qassanweh from Jordan, when they're talking about necessity operating at different levels. But I'm also sure that this course of thinking in the darker blue box, armed attack plus necessity over proportionality, need not be inevitable. In the Nicaragua case, the court, in fact, regarded the actions of the United States, including the mining of the Nicaraguan ports and the attacks on ports and oil installations, as relevant to the criterion of proportionality, not necessity. And I think that another way of thinking about this is to look at how an armed attack might actually be an integer of necessity, how armed attack demonstrates necessity in very different circumstances to those that prevailed at the time of Caroline. I think if one pays very close heed to what the court is doing in its jurisprudence, it's actually shifting the meaning of necessity to a later point it's very clear from what Webster was saying, it authorizes you to intervene. What happens after that technically came under the rubric of proportionality. In the last letter that Secretary Webster was to write on this matter to Lord Ashburton and to the Correspondence, he wrote, and I'm saying this by way of conclusion, of the great law of self-defense, by which I take him to mean a law so great, so enduring, so formidable in its reach, that it would be able to encompass a plurality of eventualities, all to be confined, he urged, to cases of the necessity he had specified earlier. And I think that I have worked on that hypothesis here, that the framework that was set down in Caroline in 1841, although it was intended for a specific, particular action of anticipatory self-defense, actually was drafted with a much broader remit in mind. And I believe that a singular framework is indeed within our sights as to regulating the right of self-defense in international law that covers diverse conditions such as nuclear warfare, terrorist activities of non-state actors, and seaborne militia. I think so because of the eminent practicality demonstrated by Caroline's authors. This is why the Correspondence repays fine study and restudy, and why the principles of necessity and proportionality may well live to see another day. Thank you.